Curious in Clinton Township who simply asks, how long should it take to quiet title? And that's it. That's the whole question.
Actually, it's the shortest question we've had in a very long time.
Yep.
I'll give you a really short answer.
All
Not
right.
long. Not long.
Not long.
No. You know, quieting title is actually a lawsuit. It's a form of litigation.
Okay.
You actually have to notify in the context of real estate investors. You're usually dealing with old liens that are showing up on title, or real estate investors have purchased a property from a tax sale. So the previous owners whose rights may have been forfeited during the tax sale, that they lost their rights, they may have to be notified by the new purchaser of that property from tax sale.
Mm-hmm.
If that purchaser of the property is now looking for title insurance. So if you have a tax deed, you're the grantee of a tax deed.
Yeah.
Now you want to go sell the property or even refinance the property. That's great. You bought the property from the county. Most title companies will say, hey, go and quiet the title because we're not clear on whether or not former property owners who may have had an interest in the property at one time were properly notified by the county of the tax foreclosure. And we as the title company do not want to be sued or have to defend in such a lawsuit. So they say to the investor, go quiet the title, okay? Those type of actions, when we're just trying to notify former homeowners that still may show up on title or may still have an interest in the property, that usually on average takes about 90 days, okay? And that's because we try and serve these folks, who may have an interest, and they either respond or they don't. If they don't respond, we get a default judgment against them, and the judge basically will say, oh, nobody responded, and so you must have clear title to the property, and I'm going to give you that clear title because nobody's objected to your new title. However, when somebody contests the title, that means that they're objecting to your interest. Mm-hmm. Now you're in for, you could be in court for a while. So that's why attorneys can't just sit there and go, oh, it's going to take exactly 90 days. Because we don't know.
It really depends. Okay.
Right. And we also don't know the judge we're going to get. Some judges are, they all go by the book, of course, but some judges will make you do a little bit more work to get that default judgment than others. Okay. And now that's in the context of just a tax sale for the purposes of most people who watch this, where real estate investors, tax sales do require that you will ultimately down the line have to go quiet your title.
Okay.
Quiet title actions also occur when people are challenging title to a property that has nothing to do with tax sale. I feel I own the property, you don't have an interest in that property, so I'll sue you, let's say, because you are challenging my interest. You have to then, you might have two competing deeds. You might have a boundary line issue, whatever it is. So you're quieting the interest, you're putting it to rest. That's where the word quieting comes from, okay? We're quieting the title, we're quieting any other claims to the property. But when people are contesting title, and that happens quite often, and we are very active in that realm, that I have one that's going on a year. The people, I have clients who hate the other party, and they're all.
Yeah, I'm sure.
And how did it get that bad? Is because I'll tell you, people generated documentation on their own. Very smart people. I like to say I clean up after legal vomit, but now I've been saying I clean up after a lot of legal vomit that was created by very smart people.
Yep.
Just not real estate attorneys, and so they find themselves in court. So.
Okay, so the quiet title action would be necessary for, not necessary, you don't need it for when you would purchase the property. It's just when you want to then turn around and sell the property. Sell the property on warranty deed. Like if you were going to quit claim it, then that does that really not matter? But it's only
Right.
if you're going to go through the title company, receive warranty deed,
Right. Yeah.
et cetera. Okay.
Right. Well, title company is going to, if you're going to, if you got to be real careful. I mean, I deal with a lot of real estate investors who buy deals and then they turn around and they go and sell and they go, I'll give them a warranty deed. It's like, no, you won't. You won't give them a warranty deed. You're warranting the title. I mean, somebody come back and sue you,
Right.
saying that you're warranting the title. Think of it like a car warranty. A deed is a contract unto itself, and you're warranting to whoever's the grantee that if there's a problem, you will defend against any claims to that property. That's what the warranty means in warranty deed. There's like 6 warranties. We won't go through them right now, but one of them is a covenant to defend the title, the grantee against any claimants to the title. So you only want to give, when you buy a property on tax sale, or not really on a foreclosure, but in a tax sale, if you purchase, you're the grantee from the county, you definitely do not want to be giving a warranty deed out to somebody else. Always give a quick claim. And a quick claim deed basically says, hey, I quit any interest. That's what it means, quit, not quiet. Now we quit. I quit any claims of interest against you or the grantee or anybody else. I'm just giving you what I have. There's no representations whatsoever in that deed. None.
Right.
So it's, I could give you I could give you a quick claim deed right now, Blair, to the Brooklyn Bridge.
Sure.
That's it.
Okay, honey. Oh, my little one just walked in again. Go downstairs, buddy. Shut the door. David and I were just talking about how I need a lock on my office door because I have a 3-year-old.
Right. That's okay. It's cute. He's cute.
So you can give me a quick claim deed to the Brooklyn Bridge, and now I own the Brooklyn Bridge. It's mine. Right. It's mine. It's all mine.
Yeah. You own what I gave you, right? Which is nothing, because I didn't really have an interest, right? Mm-hmm. Now, we also use quick claim deeds for when possibly you will have an interest in it. Let's say I give you the quick claim to a home that at this point I don't own. That I don't own. And long night. And I quick claim a home that I do not own, and I give it to you. Mm-hmm. Now, you paid me for the quick claim deed. You want it? I'm giving it to you. But I really don't own it. But later on, I somehow come into title. And I turn around and I give it to my friend. Mm-hmm. And I write a deed to them. Actually, that will not convey the title to my friend. The title will go to you.
Okay.
If you had a quick claim deed, the title flows through me into you, not into you, to you. Okay. So the previous deed actually prevails. Isn't that weird? Isn't that cool? Mm-hmm. Pretty neat.
That is.
Yeah, I mean, so that little sentence there, like how long does a quick claim, how long does a quiet title action last? Well, the answer is a lot longer than just.
Yeah, probably a lot longer than you want it to.
That's a great answer, Yep.
But, all right. Well, those were some excellent questions. I know that when you watch these videos, viewers, that it is one question at a time, but David and I actually go through a set of 6 to 8 questions, and we always do it later in the evening. So we're at the end of the final question. So it's near bedtime. We're a little loopy. My toddler's walking in on me, telling me about a cartoon that he's watching. So time to wrap it up. But if you want to connect with David or myself, my name is Blair Clark. If you want to connect with us and you're on Facebook and you are interested in, or you already are involved in real estate investing, you can check us out on a really great networking group called Michigan Real Estate Investor Network. David's very active in that group, and so am I. And there is a lot of great content put out by that networking group. And then you are probably, viewer, already watching this on YouTube. But if you're not, go check out David's YouTube channel. You can just put into the search engine David Sobel Law, Proven Resource, and his YouTube channel will pop up. There is just a plethora of videos just like this one on all sorts of concepts. And I watch David's videos on my own time ones that I'm not in and learn a lot myself. It's actually how I learned about land contracts before pursuing purchasing investment property on land contracts. So I don't know if you knew that or not, David, but he taught me everything I know about land contracts.
Just think how effective, Blair, I'm going to be when I get my law license.
Right?
I'm just kidding. I'm just playing.
Exactly. All
Anyway.
right. So David,
all right, it's time. It's time.
before we hang up, how can the folks who are watching, how can your viewers get a hold of you for all of their legal, real estate, contract, finance, estate planning, all of the gauntlet of things that you do?
Real estate, right.
And all things real estate.
It's really easy, 888-789-1715, or you can go to provenresource.com. That's simple.
All right.
Thank you very much, Blair, for spending the time. I appreciate it.
Oh, yeah. I know you're welcome. And thank you to everyone who watched us. You guys have a great night, and we will catch you next time. Take care.
Night.